Mayor, members of the City Council, I'm Jim Hoover, 3150 East Devils Lake Road. I'm a little late to the game this evening, and I was kind of surprised when I pulled up the agenda and saw that you have a first and second reading on an ordinance amending the Lincoln City Municipal Code, General Provisions, Ordinance Enforcement, and Civil Infractions. I really quickly went to the packet, and in the packet I see that the staff recommends the council conduct and approve a first reading of the proposed ordinance, not a first and second reading. Given the fact that this apparently has something to do with the request by a private citizen this week of a form on how he files a citation, because I can't find anything else in here really that I can understand in your packet, it seems to me like the public should have an opportunity to hear what this is about and then have time to comment to their elected officials from each ward and to the mayor, so that you can make a decision based on the people that you represent. So I would encourage you to not have a first and second reading on ordinance number 2015-10, but just have a first reading and allow people the opportunity to participate in the democratic process by conferring with their elected leaders after they've had the chance to hear what they're discussing and what their views are, both positive and negative, on the ordinance. Thank you very much.
Thank you, Jim. Appreciate it. Anyone else who didn't sign up?
Jim Hoover, 3150 East Devils Lake Road. Own property in the city of Lincoln City. Also have a business in the city of Lincoln City. Mayor, members of the City Council, it's really hard to talk about these following two issues without it being pointed, so I'll recognize that up front. On your agenda tonight, you have special orders of business, you have resolutions, and you have ordinances, and then at the very bottom you have a city manager, city attorney report. It says discussion of council vacancy. And it feels really disingenuous, whether it was intentional or unintentional, to put out an agenda to the public on an item as important as a vacancy in a ward where people typically elect their city councilman, stick it under a discussion topic, pass an ordinance so that you can appoint somebody that may or may not agree with the people of the ward, but may or may agree with you as councilors. You do get a chance to interview them, but you also get a chance to vote. So it's going to be voted on by 6 people, not by the people of the ward. And so shame on you. I don't know how to put it any kinder, any other way. Now, I'm also really interested, I had a chance to do a little more reading, so this is for the benefit of the people who are watching on TV who might be listening to this. Mr. Noriakis did a very eloquent job of reading the title of the first reading amending the municipal code, about general provisions, ordinance enforcement, and civil infractions. What that summary didn't say is that we're wiping out an entire section of or entire chapter of the code. I believe it's 1.20, and in the process of doing that, we're actually creating more powers for the city of Lincoln City and less powers for the individuals in Lincoln City, because nowhere in that reading did it say that we were going to deny a previous ability of a citizen to write a citation for something that was in violation of an ordinance. Nowhere in that general reading did it say that we're going to go from having about 5 people authorized to enforce ordinances to pretty much every person in the city who holds a title or is appointed by the city manager, department heads, et cetera, et cetera, et cetera. And nowhere in that does it say, in that reading, did it say that we're going to authorize these individuals to enter a vacant premise for the purpose of enforcing a municipal code or otherwise. Now, I'm familiar with who can go into a premise. A building official is authorized by the state of Oregon. That building official can go in there if there's a public safety violation, or a utility company can go in if there's a public safety hazard. But to authorize in this first reading, and possibly a second reading the next time, a city employee who holds a office in the city to go into a vacant building after giving reasonable, and there's no reason for reasonable to be defined, I guess, reasonable effort to notify the property owner, it seems like this goes far beyond just doing a little cleanup language, making a few things clear and clarifying things for something that happened in 2014. So my issue tonight is with transparency. And you're right, you guys can sit up there as a city council and 4 of you can vote to do anything you want to do, whether it's the democratic process that agrees with 51% of the voters, or whether you represent the silent minority, or whether you just downright think you know what's best. But we live in a country where people vote, and people vote for their elected leaders, and people vote through referendums and through initiatives on items and rules and laws that they choose to represent themselves. And to have something on the agenda tonight that doesn't even have a public hearing, that was represented simply as, I think I'll read it here exactly, my first reading, an ordinance amending the City Municipal Code Title I General Provisions, Chapter 1.20, Ordinance Enforcement, and Chapter 1.16, Civil Infractions. I don't think that really does justice to what people need to be informed about. And I would have loved to come up here tonight, start asking questions, and see how many of you actually read the entire ordinance, understand what it changes, what it amends, and what it leaves out. So I don't know what else to say. Like I say, I hope a lot of people are watching on TV. I hope a lot of people talk to people after they watch on TV. And I hope the citizens of Lincoln City say, no, we believe there's a process for electing people, and 3 years left on a term is plenty of time. I don't see that there's a split city council up there where we're going 3-3 on issues. It looks like we have a city council that has a pretty strong majority on specific issues. And to worry about spending $3,500, a real pittance, in order to circumvent the democratic process of having their people elect their leaders, I think is an absolutely crazy and transparent indication of where this council is going with their decisions. Thank you very much for listening.
Thank you, Jim. Appreciate it. Anyone else? Mr. Smith?
Good evening, councilors. I wasn't going to say any. Pardon?
State your name, please.
Oh, Ross Smith.
Yep.
I wasn't going to say anything, but given that Jim said something, I'd like to reiterate what he spoke about. Another thing that the new ordinance 2015-10 does is it allows for all violations to be considered continuing violations. Now, what that means is any law, any code enforcement law can now be cited for a daily offense. So whatever it is, if you don't pay your transient room tax or you don't get a business license, those already have continuing violations. But everything, every ordinance now, every code can now be continuing violation, and that's very dangerous, and that's not, let's see, that's not in keeping with the Oregon state statutes. It also requires all defendants cited for continuing violations to be required to appear in court. The ORS statutes only require the appearance if someone is involved in a traffic accident involving serious physical injury or death. So we're saying that anybody who commits a code violation where we say it's a continuing violation has the equivalent of committing a serious physical injury or death, which is pretty amazing. It also allows the city attorney to enter the courtroom during civil proceedings if the judge allows. That's inconsistent with state law. It also disallows non-attorneys from representing defendants in court, which there's no equivalent in state law, and that's probably a violation of the 4th and 15th Amendment due process claims. Allows any code enforcement officer to enter an unoccupied building without first receiving permission of the owner. I couldn't find any equivalent in state law. There's other inconsistencies with state law. Our code, let's see. I mean, it's really confusing to me that now every Class A violation will be considered a Class B violation, but we're not changing all the code to say Class B. So it'll say Class A in the code, but it actually means a Class B violation, which is very confusing. I think that's it, and I think I got under my 5 minutes, so thank you for your time.
Thank you very much.